Yes, Mr. Parker.
Thank you. May it please you, my lords. Picking up where we left off briefly before I launch into my submissions proper. As we had noted in our respondent's case, sections 255 and 256 of the Act had been repealed. But the point had been made before we took the break that the purpose of those sections were directed at a certain requirement for certainty, and particularly with respect to 255, as it then was, with respect to provable debts in the insolvency. And I think that the court would also have been taken by my learned friend in his submissions to section 1553A.
Yes.
For another treatment of the term liability, which is grouped in with other terms that continue in the event of a merger. What we say, my lord, with respect to these two provisions is that my learned friend is having recourse to these statutes without having set up a premise. And the premise that is absent is the unworkability of 272 as drafted and its applicability to the liability as found by the trial judge in the circumstances. He has not demonstrated that there would be any absurdity or any unintended consequence on the part of Parliament with the application of Section 272 to liability under Section 280. So what we say, my lords, as is demonstrated in the case law upon which we rely, is that where the plain and ordinary meaning of the statute accomplishes the objectives of Parliament without any difficulties or absurdity, the words ought to be given their natural meaning. Sparling at page 1305 of the bundles, it's tab tab 27.
This is a case we are given a new version of.
Pardon?
We were given a new version of Sparling. I don't know.
Oh, I think you may have been on Javel there.
Is that the same one?
This is Sparling Royal Trustco. This is a different one.
Oh, it's a different one. Sorry. Okay. So this is where?
This is at page 1306, tab 27. I'll start because this deals with the appellant's treatment of both provisions. There's been a push for narrowing, which was explicitly rejected by the Court of Appeal, and it has no basis. So what we say, we're citing the I will start reading from the page, the quote at paragraph 13, at the bottom of page 1304. Where it begins, and this is also at paragraph 5 of our case. Words of limitation, this is Corey, Justice of the Appeal Corey, words of limitation are not to be read into a statute if it can be avoided. This cardinal point is thus stated by Bowen, L.J. and R. and Liverpool Justices, 1833, 11 Queens Bench Division, where he stated, one objection which to my mind is almost conclusive evidence against it is reading into words which limits its prima facie operation and make it something different from, smaller than, what its terms express. Now, certainly, we should not readily acquiesce in a non-natural construction which limits the operation of the section so as to make the remedy given by it not commensurate with the mischief it is intended to cure. And Lord Hanworth in 1931 said, It is a fundamental principle in construing an act of Parliament to give it its ordinary and grammatical reading, meaning if this produces no repugnancy or inconsistency. Now, His Lordship goes on to state about a paragraph down, he was comparing two different approaches to statutory interpretation. The paragraph below has a narrow interpretation. I'll read it for the sake of completeness. He says that the respondents rely on the succeeding paragraph, which is in these terms. But in some cases, a limitation may be put on the construction of the wide terms of a statute. Lord Herschel said in Cox and Hakes, and Lord Branwell, it cannot, I think, be denied, for the purpose of constructing any enactment, it is right to look not only at the provision immediately under construction, but at any others found in connection with it, which may throw light upon it and afford an indication that general words employed in it were not intended to be applied without some limitation. Words, however general, must therefore be understood as used with reference to the subject matter in the mind of the legislature and limited to that subject matter. Now, His Lordship said, as it relates to those two approaches, I believe that the first of the quotations is more appropriate to this case. Here, the CBCA has sought to provide a remedy. An interpretation which gives effect to that remedy is preferable to one which seeks to restrict or eliminate the remedial provision of that act. And he goes on to state on the page, on page 1306, where a statute provides a remedy, its scope should not be unduly restricted. Rather, the court should seek to provide the means to effect that remedy. One of the things that I would also like to emphasize is that not only did His Lordship demonstrate that when considering the clear intention of Parliament to ensure that directors are answerable for misfeasance and oppressive conduct in office, is that you are to construe it in that vein. And what also comes from the second quote, it is not appropriate or helpful to pluck out any section in what can be an act that has innumerate provisions. It has to have some connection to the subject matter at hand in order to be said to have any interpretive value in assessing what Parliament meant with respect to the provision at hand. So what we say is that while my learned friend took the court to sections 255 and 256 and 1553A, they have no connection to section 272, and they shed no light on how the court ought to approach its interpretation. So I wanted to deal with that. Now, what is implicit from the appellant's arguments also is that they accept that on the plain and ordinary meaning of the word liability in section 272, it would encompass the respondent's claim as against the appellants. And what we say, my lords, is that what they have failed to do is to demonstrate how this creates any problems. Now, my learned friend, his presentation appeared to abandon the argument made throughout their case with respect to the question of whether or not the oppression was ongoing. And that was one of the two prongs upon which he said the Court of Appeal based its decision, and which he said was unsustainable. I don't propose to traverse that issue. It's dealt with for the avoidance of any doubt in our written case, but I would share his view that he was mistaken in that regard in any event. The second issue, as highlighted when we deal with the question of this appeal, is whether the appellants were under a liability for oppressive behavior at the time ACDL was removed from the register, which liability was continued by section 272 of the Act. As I said before the break, there was a definitive findings of fact by the trial judge that the defendants were liable at the time the company was removed from the register. In fact, the premise of the trial judge's refusal to grant relief was that it was her view that the company's removal from the register, the company striking off, expunged the director's liability. Now, on their appeal, my lords, the appellants ask for the restoration of the trial judge's decision. But what we say, my lord, is that their appeal is, although couched as a challenge to the decision of the Court of Appeal, really is a thinly veiled attack on the findings of the trial judge as against them with respect to their conduct and the question of liability. Now, my lords, the appellants contend that any liability continued by Section 272 must be one already incurred by the directors in their capacity as directors prior to the company's dissolution. However, they do not define what they mean by already incurred, although they do appear to accept by their submissions that a judgment of the court is not required. Earlier this morning, my learned friend discussed and accepted that common law liabilities will clearly be continued by virtue of Section 272. I think he also acknowledged that equitable liabilities for breach of their fiduciary duties would be continued by virtue, and liabilities under statute. Now, one of the difficulties with the appellant's argument, we submit, is how they seek to distinguish liability under Section 280 from the other types of liability that they describe. That is the difficulty that they have. Not only from the fact, based on the fact that the trial judge found that they were liable, but based on the fact that when they seek to set out statutory provisions that demonstrate statutory liability, a significant majority of those sections come under Part 9 of the Act, where you also find Section 280 itself. So that is one of the things that we say demonstrates that when you come to interpret Section 272, it is plain and clear in its language, and it does cover the liabilities as anticipated under Section 280. Now, while my learned friends do not rely on any particular authority for the nuanced definition of liability that they advocate with respect to 272, they do, however, rely on several cases: Shaw and Hyde, Shrikishan Dut, and Kamal Perker, and I'm going to say Chaudhry for the last one, for the avoidance of doubt. But what we say, my lord, is those three cases are distinguishable. I'm going to take the court to them individually. Shaw and Hyde, firstly.
Where is that?
Tab 24, Volume 2.
Volume 2.
Page 1263, 1263. I'm going to take the court directly to page 670 of that case. That's at page 1267 of the record. Are you there, my lords? Now, I'm going to start the quote by reading the provision from the relevant statute. It says, provided that the liability, if any, of every director, managing officer, and member of such company shall continue and may be enforced as if the name of the company had not been struck off the register. And the court goes on to state, I am of the opinion that the liability, if any, of every director, etc., which is kept alive despite the dissolution of the company by its being struck off the register, is the liability existing at the time of the dissolution of the company. That is a portion of the quote my learned friends relied on in their case. The portion that I will read next was not included. The court goes on to state, now in the case before me, the company was struck off the register and accordingly dissolved on February 19th, 1919, and the cause of action herein could not accrue, nor a claim for any part of the amount sued for until October 25th, 1919. After February 1919, there was no company whatever in existence, and there could be no directors, managing officer in existence. Goes on, the liability kept alive at the time of dissolution, I think, must be clearly some antecedent liability in connection with the company, which up to dissolution had a legal existence. I'll stop there. The facts of this case demonstrate that after the company had been struck from the register, a transaction was entered into in or about October 25th, pursuant to which the claimant sought to raise issues of director liability or the liability on behalf of the controlling minds of the company. What the court was saying is that in the circumstances where the company itself had been struck off in February, and the events creating the purported liability did not occur until after that fact, there was no liability capable of being continued by operation of Section 272, because at the time the company was removed, the transaction in question, the conduct in question, had not yet taken place. So we said, my Lord, that is distinguishable from the present case, wherein, as the trial judge herself acknowledged, all of the relevant conduct and the effects thereof on the respondent took place before ACDL was removed from the register of companies. So when, in this case, the court talks about antecedent liability or having a legal existence, it is relying on the facts that in that particular case, the relevant events took place after the company had been removed.
Can you help me? I mean, this is a case from 1921. Yes, and we have the statute as it was then in here, but there's also a reference to earlier cases from this country. Do we know when the provision in the form of what is now 272 first appeared in the statute book anywhere?
Anywhere?
Yes, in this country.
No, my Lord.
It has a very long history, unlike Section 280. And I'm very surprised there isn't more direct authority somewhere on what actually liability means. But certainly it goes back to 1920 in Canada. But you're not aware of any other more direct authority?
No, my Lord, I'm not aware of any, and my learned friend only goes back to 1926 in the Bahamian context.
We've seen a footnote in Pennington, but again, I'm very surprised that all we have is a footnote in Pennington and no authority, even in this country. Anyway, there it is. Thank you.
Yes. One might say the view is that Section 272 is fit for purpose, so it doesn't really occasion much debate. And I think that the appellants may be sailing very close to the wind in that regard, but that is just my conjecture. Lord, I would go on to distinguish Shirkinson Dute. The second case is in the following tab. I'll be somewhat more brief with respect to this one.
I suppose there wouldn't be any cases in this jurisdiction which would really be in point, because the liabilities that would arise under the Companies Act or in relation to companies, if you leave aside 280 or its equivalent in Canada, would be conventional liabilities either either common law or in equity, which one can readily envisage surviving under 272 or some equivalent provision. The 280 is in a different sort of category because it's creating a statutory scheme for people to make complaints to the court about oppressive conduct, and the court then to have a very wide range of remedies that it's able to grant if there has been oppressive conduct. Well, there's no, it's not a situation where, as it were, there's a liability and a corresponding right. There's rather a mischief, if you like, and a remedy for the mischief.
I don't know that I would accept that with respect, my lord. I do believe that there is a cause of action and a right, but the remedy is absolutely in the court's discretion, and it is at large. It is at large in that regard, but it is, and we're going to go to the Canadian authorities on the point shortly to demonstrate the employment of the oppression remedy and the definition of the director's liability. I would also submit, my lord, that I think underscoring a lot of what my learned friend had to say was the implicit or explicitly stated purported floodgates argument as it relates to the directors and potential claimants. But one of the things that Part 9 of the Companies Act is clear about is that the court has complete control over the process. Section 278C determines that the court has absolute discretion as to who is a complainant, who is a proper person to bring an oppression action outside of those with automatic standing. And furthermore, the court has the jurisdiction, as my lord was just discussing, to grant any order it deems fit, which includes no order. It could grant no relief. So the idea that that there would be or there's any risk of a floodgate runs counter to the fact that this is a totally, a reasonably circumscribed remedy within the court's discretion in terms of not only the relief, but also standing outside of those with automatic standing. So I wanted to touch on that.
I mean, the order that was made in this case seems to have been an order, I'm not sure, but the way it was put by Mr. Hofmeyr, I think, was that it was an order under Section 283J, that's to say an order compensating an aggrieved person. And if that's right, one might ask, when did the liability to compensate arise?
Well, that's a beautiful segue to the authorities themselves. The liabilities arise as a result of the conduct and the result.
Well, I know they arise as a result of that, but do you... Mr. Hofmeyr would argue that the liability arises when the court makes the order. Are you saying there's a liability to compensate the aggrieved person before any such order is made?
I'm saying that there's a liability pursuant to Section 280 before an order is made. The court can grant any relief that it deems fit in the circumstances to remedy that situation or to remedy the situation facing the court.
It may be enough to say there's a potential liability.
There is a potential financial obligation. There is a potential liability to compensate. That is one of the outcomes of an application under 280. But the fact that that is only one of many does not derogate from the fact that it is a liability. What Mr. Hofmeyr is saying is that because we don't know if the court is going to order us to pay anything, and if so, what, there is no liability. And we submit that that is an unsustainable premise. What Section 272 is to say, is defined, is intended to do, or designed to do rather, is to ensure that directors do not achieve any benefit from having their company struck off and getting away with whatever conduct would have rendered them liable before the company was struck off. That's the fundamental point. So the idea that the availability of, or the utility of Section 272 is circumscribed by the breadth of the remedies potentially available due to the conduct, the wrongful conduct of the directors is, we say, problematic. To deal with this, okay, if we could go to BCE, my lords.
Was there
Tab
anything
50.
Trickishin you wanted us to see?
Oh, yes, sorry, I was going down of dealing with that, but we were at Shirkishin, yes.
If you're moving on to another point.
No, I will finish the distinguishing exercise. There's only one more after this. There are 2 points about this case that are distinguishable from the present case.
Which tab is it?
We're at tab 25, my lord.
Thank you.
Paragraph 9 is the first point I would like to make with respect to this case. Page 1272. It's the penultimate sentence, well, the final complete sentence on that page, where the court noted that it was further pleaded that as the first defendant company had become defunct and was dissolved, there is no question of the second to seven defendants being directors, and that the assets of the company are in possession of the second defendant on behalf of the general body of members. I would like to point out the fact that in this case, it was neither pleaded nor denied at trial that the appellants were at all material times directors of ACDL. They did not plead the striking off of the company, even though the defense was filed in 2011. They placed no reliance on these things. I emphasize that because one of the things that the appellants stated in their case this morning was that there was no reference to Section 272 before the trial judge. Well, there was no reliance placed on the pleadings to arguments based on the purported striking off of the company. And as has been acknowledged on the record and before the Court of Appeal, there's no evidence that the requisite notice of the removal or the purported removal of the company was ever published. And there is no evidence that any of the requisite notice surrounding the purported departure from the company of Alexander Alexiou, the second respondent, was ever filed with the registry. And it is furthermore noteworthy that the second appellant purports to have walked away from the company, as the court found, in 2000, which would have been after the respondent began proceedings against the company for the judgment debt, for the debt on the promissory note, which would be relevant when we come to discuss the case of Downtown Eatery with respect to his unfair disregard. But to get back to Shirkishin, the second point is at paragraph 18, the second distinguishing element of this case. Page 1275. It begins with the second sentence of paragraph 18. But it is not, and I quote, "It is not the plaintiff's case in the plaint that any money was deposited with the directors, numbers 2 to 7, or that there was an agreement between the said directors and the plaintiff that the former would pay the amount to the plaintiff." Now, the court based its dismissal of the claim as against these directors on the fact, as is demonstrated in paragraph 18, that there was no substantive claim pleaded as against them. And what in fact occurred, as you will see if you continue to read paragraph 18, the counsel sought to rely on the proviso with respect to the continuation of the director's liability. And the court found that at the bottom of paragraph 19, this proviso only means that the existing liability of any director or member prior to the dissolution of the company will continue in spite of the dissolution. If the directors are not personally liable for the plaintiff's claim prior to the dissolution of the company, they will not be liable after the dissolution. So what we would say, my lords, is that distinguishing this case from that, the appellants were the only defendants in the subject case, and the claim as against them was specifically pleaded that they were personally liable in the circumstances. And Section 280 affords the right of a complainant to apply for specific relief. And in this case, the respondent pleaded for an order that the defendants compensate him. Okay. Mr. Do you have it? Okay, now we're going to turn to the third case that they rely on, my lord, that the appellants relied on with respect to this suggestion. This is the Chaudhry case. This was at tab 18 of volume 1 of the authorities. Paragraph 5 thereof, the court's treatment of the relevant issue. Says that the purport of Proviso A, in our opinion, is entirely different. It merely continues the liability of the officers, including the directors of the company, existing, if any, on the date of its dissolution. It does not convert the existing liability of the company on its dissolution into that of the officers named in the proviso. The liability of such officers contemplated under the proviso is their liability, quo such officers, which was existing on the date of the dissolution. If the named officers had no liability independent of the liability of the company on the date of dissolution, the proviso does not come into play. In this case, there was patently no liability of the petitioners as directors on the date of dissolution of the company in the matter of the discharge of the debt arising as against the company as a result of the award passed against the company. That is, we say, my lords, another distinguishing feature, and we also again highlight the fact that the question of liability was determined in the respondent's favor by the trial judge. I want to turn to Cox. In volume 1. This was a useful point, my lords, to turn to the case of William Cox and Aspen Veterinary Services. I want to take the court to a proposition in there. Tab 19 of volume 1. This is a case where the court held directors liable to a complainant personally for a compensatory order. But I want to take the court to paragraph 159, page 1204 of the record. Okay, it reads, Dr. Jazz and Dr. Curry say that holding them liable to Dr. Cox for his liability to enforce his security, for his inability rather, to enforce his security amounts to implementing now the personal guarantees that he did not obtain in January of 2000. This is not correct. The reason that Dr. Jazz and Dr. Curry are liable to Dr. Cox is that they engaged in conduct that had the effect of unfairly prejudicing him and unfairly disregarding his interests by preventing him from enforcing his security. They are not held liable simply because J Tree and Willow are unable to pay him. And what we say, my lord, is that it demonstrates the treatment of liability under the oppression remedy.
What was the provision under which they were found liable?
They were found liable under section 234 of the, I think it's the Saskatchewan. Just 1 second. Yes, section 234 of the Business Corporations Act.
You find that on page 1166.
Yes, paragraph 46.
So that's very much the same as our 280.
Yes, please.
And sorry, what's the point you're making about this?
Oh, sorry, yes. The point we're making about this, my lord, is that as you'd see, the complaint of the respondent as against the defendants, as the appellant directors, was not simply because the company did not pay his debt, did not satisfy the judgment debt. It was based on the fact that they had conducted themselves in contrary to Section 280 in a manner that had the effect of unfairly prejudicing him and unfairly disregarding his interests and preventing him from securing relief on his judgment. And what we say, my lord, is that that is a direct right of action in the toolkit of the aggrieved creditor by virtue of Section 280. Now, my lords, it is essential or central to the respondent's argument that Section 280 is substantively distinguishable from liability for acts of mismanagement or misappropriation in the performance of their duties, all of which they say are liabilities defined by statute or common law and which exist as a matter of right. However, my lords, what we say is that this is not substantively maintainable, this assertion. The acts of mismanagement or misappropriation in breach of their duties committed by the appellants in this case are the basis of their liability and the basis upon which the respondent was entitled to the remedy ultimately awarded by the Court of Appeal, UKPC again. Now I can go to BCE. Tab 15, my lords, of the volume 1 of the authorities. Paragraph 90, I'm going back to an exchange I think that my learned friend had with Lord Hodge with respect to equitable claims as against directors. You see that the court in BC said at the final sentence of paragraph 90, nevertheless, it's worth stating that as in any action in equity, wrongful conduct, causation, and compensable injury must be established in a claim for oppression. The elements of their liability. These are the ingredients as the trial judge relied upon in finding liability.
So which paragraph? I'm sorry.
This is paragraph 90,
90.
the final sentence. So what we say here, my lords, is that as was found by the trial judge, there was wrongful conduct, not in dispute. There was causation, and there was compensable injury on the part of the respondent, which grounded the claim for compensation. As the case law demonstrates, a claim for compensated relief against directors has to be specifically pleaded, and you have to specifically plead the basis upon which you assert that the court ought to grant that particular remedy. And what we say is that this demonstrates the ingredients of the liability that we say was continued by virtue of Section 272. The convergence of the wrongful conduct, causation, and compensable injury occurred before the company was removed. I'll take the court now to Budd and Gentra. This is the tab 16 of the same bundle, bundle 1 of the authorities. I'm going to be at paragraph 30. Tab 16, I said. Tab 16, sorry, my lords. Where the court stated, under section, the relevant section is right above at paragraph 29. I'm reading from paragraph 30.
So could you give me the page number again?
Oh, yeah, sorry, 1093. Section 2413 vests the court, and I'm reading, with broad remedial powers. It provides that in rectifying the matter complained of, the court may make any interim or final order it thinks fit. Those words are followed by a list of 14 orders which may be made, and the express indication that those specific orders do not limit the generality of the remedial power given in the opening language of section 241, subsection 3. I paused there for a moment because during my learned friend's presentation, he sought to read words after any order it thinks fit, when in fact we say that the court's power, as is noted here, is general, and that some of the orders made, as my lord indicated, are not necessarily in and of themselves directed to rectification or restraint. They could, as the court indicated, be related to a trial of any issue or other things. But I wanted to take that point there. But to go on, the specific orders referred to in section 240.13 include the power to require any person to pay a security holder any part of the monies paid by him for securities, and the power to compensate an aggrieved person. Both orders can be made against the company and or individuals, including directors. Now, I will go to paragraph 33 on the following page. Section 241 provides a statutory means whereby corporate stakeholders may gain redress for corporate conduct, which has one of the effects described in 241.2. The section serves as a judicial brake against abuse of corporate powers, particularly, but not exclusively, by those in control of a corporation and in a position to force the will of the majority on a minority. Section 241 enables the court to intercede in the affairs and operation of the corporation and effectively override the decisions of those charged with the responsibility for governance. And the final portion of that particular section I want to read is from paragraph 36, which brings it home to relation to the respondent's claim, where the plaintiff seeks a remedy against a director or director or officer personally under 241. I do not think it is accurate to suggest that the plaintiff is attempting to circumvent the principles with respect to personal liability of directors and officers. On the contrary, the plaintiff is making a fundamentally different kind of claim than is contemplated in cases like Peoples. The plaintiff is not alleging that he was wronged by a director or officers acting in his or her personal capacity, but is asserting that the corporation, through the actions of the officers and directors or officers, has acted oppressively, and in that circumstances it is appropriate, i.e. fit, to rectify that oppression by an order against the directors personally. Now, my lords, I cite those things, I mentioned those particular provisions, judgments rather, to emphasize the nature and the substance of the claim under Section 280. That it is a cause of action in its own right, and it is a right vested in a stakeholder to seek to have his interests protected and vindicated in the face of offensive conduct by directors and officers and companies. So, to suggest that it is somehow not in the nature of other claims that directors may be subject to insofar as to exclude operation of Section 272 to the liability flowing therefrom would be to unduly circumscribe the availability of the remedy to the stakeholder and the intention of Parliament in providing that remedy to complainants. My learned friend says that when Section 272 was first introduced in the Bahamas in 1926, they could not have imagined Section 280. However, when Section 280 came into force, it was well within Parliament's purview to create the narrowed application of Section 272 that my learned friend advocates for. But what we submit is that the Parliament deliberately intended to make available this right on the part of complainants who are able to satisfy the court that they are fit and proper persons to seek redress directly against directors and officers who commit the kind of offenses that the appellants were found to have committed. My learned friend has not demonstrated any substantive basis upon which the Court of Appeals treatment or handling of Section 272 can be impeached. The appellants did not appeal the trial judge's finding that they were liable. They did not appeal her findings that the oppression was ongoing and that their conduct fell foul of Section 280. All of these things were established and beyond dispute before the Court of Appeal. But in their appeal before you, my lords, they seek to suggest that the Court of Appeal erred in applying Section 272, when in fact the Court of Appeal had before it a judgment of the Supreme Court, the trial judge, the principal finder of fact, that the appellants were liable. So, my lords, we see that the second prong of their attack on the appeals, the Court of Appeals judgment is unsustainable. I mean, it is something that they cannot get around. And, my lords, we also have to emphasize the fact that only one side, only one party before you has put forward what we say is a workable definition of the term liability as used in Section 272. The appellants did not even condescend to seek out, I mean, they may have been unable to find one, but a definition of liability from some source, from some authoritative source, that would accommodate their view. But we say, my lords, fundamentally, when we look at the facts of this case, my learned friend referred to situations around the world. Well, it cuts both ways. If it can be that directors can conduct themselves in the manner that these appellants have been definitively found to have conducted themselves, and as the court found, actively caused the company to be struck off, and then appear before the court to suggest that their liability for that conduct, as was found by the trial judge, cannot be continued by virtue of Section 272, that is the real floodgate that we have to be concerned about. Because Parliament clearly intended, as the appellants acknowledge, that the purpose of Section 272 is to make sure that directors do not gain any advantage in covering their tracks by having the company removed. And that is a fundamental lens through which the court ought to view the consideration of these issues, because the fundamental findings of fact are not in dispute. The question of whether they did it, the court found that they did it. Whether they were liable, the court found that they were liable. Unchallenged findings from the trial judge, unchallenged findings from the Court of Appeal. They are asking the board, to overturn all of those findings. And we say that they have not demonstrated any reasonable or lawful basis upon which the court can adopt the artificial, we say, interpretation of Section 272 called for by the appellants. They say, my lords, in their case, the company was struck off, and therefore, as at the date the action began, there was no company and there were no directors of the company. Section 272 says otherwise. It says that when you are coming to determine the question of the potential liability or the liability of directors of a company where it has been struck off, their liability is to continue. And that question is to be answered as though the company was not removed. So it is not open to a delinquent director in a case on a question regarding his liability to say, well, the company actually doesn't exist. Section 272 is designed to prevent that argument from running. So when we come to consider the question of the liability under Section 280 or their liability otherwise, the question is it open to the court under Section 272 to have regard to the fact that the company is removed from the register? Because the question is supposed to be determined as though the company had not been removed. That's what Section 272 provides. So, my lords, what we say is that the appellants have failed to define or to place liability under Section 280 as found by the trial judge into a distinct and discrete category that does not continue by virtue of Section 272. They have failed in that effort. I would also like to take the court to GC Capital. Where's GC? There they are. It is at tab 22. On this question of director's liability. That's a 21, sorry, my lords.
21,
21, yes, my lord.
GC Capital.
Page 1243. Paragraph 40 is where I'm going to begin. Director liability, I'm quoting, director liability is also found in legislation. For example, Section 2422C of the Alberta Business Corporations Act 2000 permits an oppression claim against a director if the powers of a director are exercised in a manner that is oppressive or unfairly prejudicial to or unfairly disregards a shareholder's, directors, or officers or creditors' interest. This language is similar to that used in Section 667 of the Alberta Condominium Property Act in relation to liability of a developer. I'll step outside and say it is also similar to the legislation under consideration here before the court.
Do we have the Albertan provision anywhere? I'm just wondering if it's actually worded in a different way from the provision we're dealing with. It may be that, I don't want to hold you up if Ms. Quant is able to look for it, perhaps.
No, I thought it was in one of the lists that was exhibited.
Oh,
They
yeah.
have the other provinces, but they don't have Alberta.
Right.
Sorry. So yes, my lord. And I'm going to go on. Liability has been imposed when directors or officers personally benefited from the corporation's oppressive conduct or furthered their control over the company through the oppressive conduct. Such cases often involve closely held corporations where a director or officer has virtually total control of the corporation. In such situations, he or she has been held personally liable to rectify the corporate oppression. I will move quickly to paragraph 47 of the same ruling. On the facts, it is certainly arguable that Mr. Chow could be personally liable. The arrangement that he allegedly orchestrated was arguably outside of or contrary to the legal obligations and duties of the corporate developer, Gateway McLeod, and was a benefit to him personally. A director, and I'm emphasizing a director in a closely held corporation who carries out such actions risks personal liability. In such situations, it can be argued that the corporation was not acting in a manner required of it, but rather its actions had been hijacked by an individual who caused it to act improperly for the individual's own personal gain. Now, I take the court to GC because in this case, the court treated the liability under Section 280 as the director's liability, and that if he acts in a certain way, he risks personal liability. And what we say, my lord, is that the same is true under Section 280 of the Bahamian Companies Act. If you conduct yourself in a certain manner, offensive to the provisions, you risk personal liability. The defendants, the appellants rather, conducted themselves in the manner as found by the Supreme Court, and that conduct attracted liability. And that liability was continued, as we say, by operation of Section 272.
For what it's worth, I looked up the Alberta Act here. Section 242 looks pretty similar to the other ones we've seen.
Obliged, my lords, the premise of the respondents, the appellant's claim is that until the court's discretion, this is paragraph 69 of their case, until the court, for the reasons set out here, they maintain that until the court's discretion is exercised in favor of an order imposing personal liability upon a director, no liability exists at all. There is accordingly no liability capable of being continued under Section 272. The Court of Appeal was wrong to conclude, they say, that the appellants were under a liability at the time and before the Court of Appeal exercised its discretion to impose an order requiring payment of compensation. Those two premises, we say, as for reasons we have articulated in our reading case and as I have traversed today, are unsustainable. Firstly, we say that it is the conduct of the appellants that occasioned or triggered their liability, not the relief granted by the court. And it is that liability that is continued so as the court can be empowered to make a decision or to make a determination as to what remedy to give, if any. And we say, therefore, that the liability does exist prior to the imposition of personal or a fixed financial award. And we also say that the suggestion that the Court of Appeal concluded that was wrong to conclude the appellants were under liability is a mischaracterization of the facts and findings before the Court of Appeal. The Court of Appeal, as I say, upheld the trial judge's findings as to liability and were therefore also right to find that such liability continued. And we say that, and as our submissions, written case demonstrates that when the court has findings of the conduct of the nature before it, I want to double check. An order compensating an aggrieved person is a reasonable result and is the appropriate result. Now, the final point I want to make, my lords, is with respect, to respect to the relief. One of the points that my learned friend made is that after the court has been, after the company has been struck off the register, the orders available to the court, the remedial orders available to the court, would be circumscribed by that fact. And therefore, that is of some concern as to whether or not such liability should be continued. But what we would say, my lord, is that the conduct of the defendants, with or without the company having been removed from the register, may demonstrate the need to make an order directing them to pay the complainant personally. They've stripped the company. They have, by their evidence, manifestly determined that they will not pay anything on this debt. It was in evidence and confirmed before the court in the first trial and in this trial that the company was profitable. So the question of making an order, appointing a receiver, or those things, had the company not been struck off, would have also been, we would say, not an effective means to rectify the situation. I'll take the court, finally, my lords, to tab 61. This is the case of Danilchuk and Walensky, paragraph 56.
This is tab
Sorry, tab 61.
61.
Oh, I have 25 minutes? Okay. Sorry, not finally then, my lords. This is paragraph 56, where the court said, another case in which a money judgment was awarded is Wilkinson and Today's Carpets Limited.
Which page are we on now?
We're on page 1752.
Oh, sorry. Yeah. Thank you.
Welcome. Another case in which a money judgment was awarded is Wilkinson and Today's Carpets Limited. J.T. Edwards, J., dealt with the issue of remedy following a finding of oppression in these words. Having concluded that certain acts that have been done are oppressive and I think unfairly prejudicial within section 201A and B, it is now incumbent upon me to make the appropriate order under section 200, subsection 2. In the circumstances where the company is inactive and is not likely to be able to satisfy a monetary order, and where Mr. and Mrs. Gates are the beneficiaries of the unlawful acts under consideration, I believe it is appropriate to make an order under section 202C, providing for the purchase of the shares of Mr. and Mrs. Wilkinson by Mr. Gates. The next
What are we to take from that?
It goes on, I'm going on to, we take from that the fact that, oh, sorry, Balance, is that when you have a situation where the company in and of itself, through the conduct complained of, we are submitting, or is not operational, or is not functus, that the order compensating an aggrieved person naturally flows. And what I'm trying to say, Balords, is that my learned friend submitted that because the company is struck off, the court's hands would be tied potentially to always go towards a money judgment, which I think the underlying implication is that that is inappropriate. But what I'm trying to say, and I'll go on further in the case to demonstrate again, is that when you have situations where defendants conduct themselves like this, when they scuttle companies, when they strip companies, when they have manifested an intention not to act in accordance with their duties, it is that kind of conduct, A, which results in companies being struck off, and B, which tends to direct the court down towards compensatory orders directly. And so it is to address the implicit argument that it is somehow the circumstances of the striking off somehow predisposes the court to making a financial order, whereas what we say, as the case law demonstrates, it is again the conduct of the defendants that predisposes in the cases, the court to awarding financial compensation.
Yes. Can we look at it this way? Before the company was dissolved, the company had a claim against its directors on the findings of the trial judge for breach of statutory duty under Section 81.
Yes.
And the findings seem to include the fact that the company was earning about $60,000 at the outset of the sale, which was less than than your client had certified. That was the complaint made against your client.
That was the allegation, yes.
But that allegation wasn't made out eventually in the suit by you against the company. I think that's right, for payment.
Yes.
Yes. The trial judge also held that the successor company was successful in essentially the same field of business from
Yes.
the same premises.
Yes.
Yes. And that assets, leasehold and stock were diverted to that company. And they also held that the accounts produced weren't acceptable, and no explanation was given as to the property transferred or its value, and no explanation even as to when the company ceased trading. I think those are all the findings.
Yes.
Yes. In those circumstances, if the company hadn't been struck off, would you have had a remedy?
Yes, Justice Malone. Yes.
Yes, and what would it be?
The Section 280 provides that a complainant may apply for any order or for an order.
Yeah,
So
even without Section 280,
yes,
would you have a remedy?
we would have to be derivative, I would say. It'll be
You would have a derivative remedy.
yes.
And you say, as I understand it, that, or you accept the Canadian jurisprudence to the effect that part of Section 280 is to simplify what may be achieved more clumsily by the common law.
Indeed, indeed. Particularly with reference to the derivative action and that process.
Thank you.
My letter took the court to Gower. I wanted to go to Gower. This is a tab 33. This is the quote again where Gower provides that the range of matters which the registrar must keep in mind upon its application upon an application under Section 1003 is much reduced by the provision that dissolution under the procedure does not inhibit the enforcement of any liability of the erstwhile company's directors, managing officers, or members, so that those people cannot escape common law statutory duties by causing their company to be dissolved. Now, we say that that is a restatement of principle that would equally apply to the claim of the respondent in the circumstances. We do not see that as a premise upon which the respondent's claim could be distinguished. The same mischief is to be prevented. If the same mischief is to be prevented.
The short question seems to be whether the creation of a statutory scheme which vests in the court the power to create statutory liabilities under Section 280 in substitution for longer-winded processes which, for example, might involve the enforcement of the duty arising under Section 81, makes a difference to the application of Section 272.
That's the long and short of it.
Yeah.
Yes, my lords, that's the...
And the issue really is whether liability in 272 includes potential liability.
Yes.
That's the fundamental point. And to Gower's, and well, actually, I don't even have to resort to Gower. My learned friend relies on several statutory examples of so-called defined liabilities under the Act existing as a matter of right. Paragraph 52 of their submissions. They suggest Section 27 renders a director personally liable to the holder of a bill of exchange, promissory note, check, or money order for goods in the circumstances therein set out. Sections 100 and 102 renders directors jointly and severally liable to the company in circumstances therein set out. Section 286 renders directors liable to a civil penalty in the circumstances therein set out. What the Act does, it says that if you conduct yourself in a certain way, there is a fixed penalty, but in each instance, the Act provides that by summary procedure, on summary conviction, you can be fined a fixed amount. And what we say, my lords, is that that is a distinction without a difference, insofar as the only distinction between these provisions is that the liability, the penalty, the remedy at the end of the day, or the sanction is fixed. But in no instance is there an absence of judicial process. In every instance of the statutory offenses that my learned friend cites, there is a process where the court can find you either committed the acts in question or didn't. And as I said earlier, much of these, Section 286 to 289, fall under Part 9 of the Act, as does Section 280 itself. So what we say, my lords, is that my learned friends have failed to demonstrate that the term liability as used in Section 272 is not broad enough to accommodate potential liability as my Lord Reed put it. But what we maintain, as was demonstrated by my citation from BCE, is that the ingredients of the liability existed: the wrongful conduct, the causation, and the compensable injury. And we say that that liability is no different than any of the other liabilities that the appellants describe as automatically satisfying the requirements of Section 272. And
we keep coming back to the same point. Mr. Hofmeyr would say the difference is this, that liabilities arising under statute or common law or equity arise by operation of law when certain factual conditions are met. Whereas the liability which may be imposed, it doesn't arise under law, but the liability which the court may impose under Section 280 depends upon the court's deciding that that's the most appropriate means of remedying oppressive conduct.
Well, it's described in BC as an equitable remedy. And what we say is that I view my learned friend's submissions as saying that until a monetary order is made, there is no liability. But I believe that that is not correct. You don't get to the monetary award, you don't get to any of the relief that the court has a discretion to provide without the question of liability being established. And liability is established based upon your conduct. And the Act sets out the parameters. It says that if you act in these ways, you've acted contrary to the Act, and you are liable. And the court, when it finds you liable, can do any of these things. So I don't see where my learned friend says that until an order is made, there is no liability. When in fact, he, by his submissions again, acknowledges that Section 272 anticipates an action to begin after the company has been removed. The question, those things are determined in the context of an action. Your liability pre-exists. It's the basis of the claim. And which is why I started with the trial judge's consideration at the strikeout application of whether or not a potential claim is made out. And what she determined is that, assuming all things are as stated on the originating summons and affidavit, there is a claim, there is a liability that may result in relief.
Well, if Section 280 didn't exist, but Section 272 was there, and you had a breach of statutory duty under Section 81, the remedy wouldn't necessarily be the return of the property. It could be an account for the profits made by those assets after they had been transferred to the other company. So there would be a range of remedies available to the court in its discretion for the breach of statutory duty. And if liability is excluded by the existence of that range of remedies, then Section 272 wouldn't cover this breach of statutory duty.
There is no, to the court's point, on the factual matrix, they don't get away with it, as the court says, but based on the findings that have been made against them. And we say that Section 272 is designed to specifically prevent that, and my learned friend is seeking to articulate an unsupported or amorphous definition of the term liability based on what he says is the uncertainty that it would be occasioned to directors. And we have treated with this in our case, and we have said that the perspective is wrong, we say. We say that the whole purpose of Section 272 is to make sure that those who conduct themselves, the statute is there. It tells you what you cannot or oughtn't do. So there's no real uncertainty, and there's no real floodgates argument, because the court is there as the final check. But what can't be said, and this is what I really want to emphasize, that the respondent as a stakeholder, as a complainant who was found to be a complainant properly so by the trial judge, that his claim as against the directors is excluded from continuation by Section 272. My learned friend has not provided a substantive basis for that assertion.
I wonder whether the analogy with different remedies for breach of fiduciary duty really holds. If the director acts in breach of his fiduciary duty, he's undoubtedly under a liability for breach of fiduciary duty. There's a choice of remedies in that the remedy might be an account of profits, or it might be compensation, depending on which the court thinks is the more appropriate. But there's no doubt that there is a liability existing on the part of a director. The difference in the present situation may be this, that where there's oppressive conduct for which a director is responsible, it doesn't necessarily follow that the director is going to be under any liability at all, because the court might grant a remedy which didn't lie against the director. It might, for example, put the company into liquidation.
Well,
and then allow a liquidator
yes.
to pursue whatever remedies seemed appropriate.
Even in a claim against a director for his conduct complained of under Section 280, the remedy, we acknowledge that the remedy is not circumscribed to the financial compensatory, but the point I'm trying to make is that the fact that the court can decide not to make that particular order or a particular order of that nature does not derogate from the fact that if a director conducts himself in this manner, he would be liable for that conduct. What the remedy, how the court determines to rectify or restrain or is at large, I accept that.
Yeah.
But the suggestion that you can conduct yourself in this manner contrary to clearly articulated parameters and say that you are not liable until the court tells me I have to pay you,
Yeah.
it makes
That's the same point. You say it's enough that by his conduct he has laid himself open to the possibility of the order being...
Indeed. And that is exactly what is continued, because at the end of the day, it is open to a complainant to have a fighting chance. And that's what we say, my lords. I already said that.
We're going round in circles here, I think.
And to the point of breach of fiduciary duty, the trial judge found that the conduct perpetrated by the appellants or committed by the appellants was in blatant disregard and in violation of their fiduciary duties.
Yeah.
And the Court of Appeal gave that order.
Yes, I come. It's almost time.
Lords, as I've concluded, one thing that I would like to emphasize is that, as we say in our conclusion, in our submissions, the counsel for the appellant state that the respondents' failings, and I'm quoting them at paragraph 74 of their submissions, the respondents' failings cannot be properly laid at the appellant's door. Section 272 cannot properly be construed so as to give an aggrieved creditor after the fact protection against risks that the creditor assumed when he contracted with ACDL and against which risks he has since failed to protect himself. As I say in our submissions, we find that alarming, and we say, as we say in our submissions, that it cannot be right that a stakeholder is required to contract with a company that he not be oppressed, that he not have his interests unfairly prejudiced or unfairly disregarded. And what we say is that Parliament specifically determined that that not be the case. And they specifically provided that directors and officers not conduct themselves in manners so as to lay themselves open to such allegations. So it is not a question of the respondent failing to protect himself. As the trial judge found, he did everything a reasonable commercial actor would do to protect themselves in a commercial situation. And it was the unforeseeable actions and breaches of duty by the appellants that occasioned the oppression and the result that he suffered. And so we would say that the Court of Appeal, by their ruling, laid responsibility at the appropriate party's feet. Thank you.
Well, thank you very much indeed, Mr. Parker. Ms. Quant, do you have anything to add? Thank you. Mr. Hoffmeyer?
My Lords, in responding, it's important in my submission to see that there are two arguments being raised, which are distinct arguments, albeit they may be related arguments. The first argument is based upon Section 280 of the Act, and that's perhaps best illustrated in paragraph 4 of my learned friend's case in the second and third sentences. The relevant date for determining whether liability exists under Section 280 is the date on which the conduct takes place, not the date on which the conduct is found to attract liability. And that is expanded upon in paragraph 18, 20, and 22 to 23. There is a separate argument which is based upon the construction of Section 272 and it's asserted in paragraph 5 of my learned friend's case, sentence 1, that the appellants seek to have an unnatural and unduly restrictive tether placed upon the interpretation and application of the word liability as used in section 272. And so, with respect, it's important to bear in mind those separate arguments. The one is effectively asserting that section 280 should be construed as giving rise to liability, properly so called. And the second is, it seems probably in the alternative, that if it's not given that meaning, then the word liability must be construed more broadly in section 272. May I then move secondly to deal with the question of fiduciary duty. A fiduciary duty is a legal obligation. It's variously described as a common law duty, a statutory duty, and as an equitable duty. For present purposes in the Bahamas, it's a statutory duty under the Companies Act. But those labels merely tell us something about the historic source of the obligation. They tell us nothing about whether or not there is a liability, namely what constitutes liability. And under section 272, one is not concerned whether behavior has been good, bad, or indifferent. One is concerned with whether or not a company or an individual is under a liability. Is the individual under a present obligation to another? And it's in that context that we say that if the relief is discretionary, if the relief is discretionary, there is no liability in existence until that relief has been pronounced. Until it is pronounced, for the purposes of section 272, there is no liability. And that, in our submission, is the important distinction to be drawn. One is a consequence as a matter of law, and the second arises on the exercise of a discretion. The third general point is the question of route to a recovery. In our submission, whether or not there might have been another different route which could have been taken is neither here nor there. The position before the Privy Council today is whether section 272 was the appropriate route, and we say it was the wrong route.
Section 280?
Good.
Not section
No, section 272
was the route.
is because what happened at first instance and in the Court of Appeal in the context of section 280 is neither here nor there unless at the date of dissolution there was in existence a liability. And that's a question which arises under section 272. And the only way in which the complainant can proceed in circumstances where there are no directors in existence, then there is no company in existence, is through the gateway of section 272. My lords and my lady, you were taken to a number of cases. You were taken to Sperling in relation to statutory construction. We don't disagree with the principles identified. All of the cases to which my learned friend went to were cases on Section 280 or its equivalent, and as to the scope of that. And again, I don't believe any of those principles are contentious. But it just perhaps to assist us in the context of the question of liability, may I very quickly refer your lordships and your ladyship to the Supreme Court of Canada case in Wilson at Divide 29, page 1322. And I was going to invite the court to look at paragraphs 40 and also at paragraphs 51 and 52. And at the end of paragraph 40, one sees the court identifying the exercise upon which it has embarked. And in the final sentence, state this: therefore, although the presence or absence of control may be considered as a factor in determining whether it is fit to impose personal liability, it is not a necessary criterion for personal liability. And the court understood itself at the stage of considering an application under 280 whether or not to impose or hold a person liable, and that's true, repeated in 51 and repeated also in 52. None of the cases proceed on the assumption that the conduct is akin to liability. They are looking at whether liability should be imposed by means of a relief under Section 280 or its equivalent. Perhaps a very small point, but just to correct the impression, contrary to the respondent's assertion, the appeal does not attack any findings of fact. The findings of oppression and unfair disregard are accepted. The appeal challenges the Court of Appeal's reliance upon Section 272 as a means of indirectly overturning the conclusion reached by the trial judge, which was a conclusion of mixed fact and law, that relief under Section 280 was not available to Mr. Galantis.
One thing that is, I see, emphasised by the Supreme Court in Wilson is, well, the way they put it in paragraph 56 is that fashioning a fit remedy is a fact-dependent exercise. And they cite a decision from one of the appeal courts to the effect that the point at which relief is justified and the extent of relief are both so dependent upon the facts of the particular case that little guidance can be obtained from comparing one case to another, and be hesitant to enunciate more specific principles of approach than have been set out. And it's described in 57 as a flexible and discretionary approach.
And the normal approach in relation to appeals is set out at 59, again, which is because of the fact that it is accepted that two judges based with the same facts before them may come to different conclusions, so long as they've applied the correct principles and therefore there is no there's no invariable result at all when a discretion is being exercised. Which, my lords and my lady, brings me to my next point, which is to address what has really become, I think, my learned friend's primary assertion, which is that it's conduct which triggers liability, not relief. And in that regard, that was, as we have asserted this morning and explained, was the mistake made by the Court of Appeal in equating oppression with liability. And that, with due respect, is an unsustainable argument for the reason that I've just given, because under Section 280, the same conduct may lead one judge to impose compensation, it may lead another judge to order winding up, and it may lead a third judge to make no order at all. And mere oppressive conduct cannot therefore equate with liability. May I then just very quickly, two things left for me, if I may, deal with the allegation that the judge found the appellants under a liability, and for that I'm going to invite your Lordship and your Ladyship to go to the judgment, which is in the record at divide 20. And to put it in context, we say that the respondent is mistaken when he asserts that the trial judge found the appellants were under a liability for unlawful conduct at the time the company was removed from the register. If one goes to paragraph 144, which is the paragraph that's relied upon, the sole paragraph, page 654, relied upon for that assertion, and in particular the second sentence, the defendant, in such circumstances, the defendant's liability has been expunged because the vehicle for enforcing the claim, full stop. That sentence does not bear the weight of an assertion that that is a finding of liability. On any view, it's an incomplete sentence. Without knowing what the sentence should have been, its meaning must remain unclear. But it's nonetheless apparent, we say, from the judgment, that in the opinion of the trial judge, the outcome might have been different had action been taken before Alicat Designs Limited was struck off the register, and there are numerous statements to that effect. See, for example, paragraph 133. Should have taken action to enforce the court order in a timely fashion. Should have brought this action before its company was struck off the register. 146. He unfortunately did not bring his claim before the company was struck off. Had he done so, he would have had an arguable case of oppression against Mr. Anthony Alexiou, and had he brought the case before Alexander Alexiou left the company, he would have had a potential claim for unfair disregard, paragraph 148. In this case, the complainants must have been aware of the facts and circumstances before 2008 when the company was struck off, yet the action was not brought before 2009. Simply put, the complainant did have an arguable case, but like JAXA, the complainant decided to sit on his rights for an extended period of time. This conduct took him outside the purpose and scope of the statutory remedy. The oppression remedy now invoked was available to the complainant before 2008, whenever he first discovered liquid desert where his premises used to be. The claim should have been brought when he first discovered the misconduct complained of. On this ground alone, the complainant's action under section 280 must fall for lack of temporal connection. And similarly, in paragraph 151, the complainant really ought to have enforced judgment against the defendants for the previous action, rather than letting it escalate to the point where the company had not only ceased doing business, but had also been struck off the register. And at 154, however, the complainant's request to bring an action in the name of the company against the defendants in Bahama Republic Limited cannot work, seeing as the company no longer exists. The court would have been in a position to intervene and might even minded to give remedy to the complainant had the action been brought before the company was struck off the register. So having regard to these statements, the reference in paragraph 144 to the vehicle for enforcing the claim is best read as a reference to the company, which no longer exists. Moreover, having regard to the whole of the judgment, see, for example, the references in paragraph 146 to arguable case, potential claim, 148, an arguable case. The reference to liability in paragraph 144 is surely read as a reference to potential liability. Indeed, in our respectful submission, the child judge was simply reiterating in different language her conclusion that since the company had been struck off the register, the actions complained of were not susceptible to being corrected and there were no directors capable of being restrained. In other words, that the case fell outside the scope and purpose of section 280, such that there was neither a legitimate claim nor an existing liability. The highest Mr. Galantis can put his case is to assert that the facts of this case are a classical example of where the oppression remedy will bite, and that liability on such facts is inevitable. Well, in a broad sense, but I mean, one aspect of the facts here is that we're told by the judge at paragraph 141 that the complainers were the only major creditors. And if they're the only major creditors, then that would be a reason for granting a remedy against the directors, so that those creditors get paid. If, on the other hand, they weren't the only significant creditors, then I'd have thought the court would be likely instead to put the company into liquidation so that any assets recovered from the directors could then be distributed pari passu. And indeed, my lord, depending upon the financial state of the company, and much is made of the fact that assets were transferred and a lease, the lease was just about at its end, and in reality had little or no value. So far as the company's state at the time is concerned, if the proceedings had been brought right at the outset, it is most likely, indeed, that the court would have said that the appropriate thing to do in this case is to look and investigate the company's affairs, look at if the stock that was taken over was worth $100, then it wouldn't have helped a great deal. If it was worth $100,000, it might have, but there's no suggestion that it had that sort of value. And
Yes, well, the point I really had in mind was really related to what the Canadian Supreme Court had said, that we're not dealing with a situation where the minute the asset stripping happens, you can say the most appropriate thing for a court to do on an application under Section 280 is inevitably going to be to grant a remedy against the directors, because it may be by the time that any application is made to the court, there are a whole number of other creditors whose interests are at stake, in which case the appropriate remedy might be one that was designed to benefit all creditors rather than only two. Well, I mean, the court, no doubt, would take a view on what it thought was fair in the circumstances.
Circumstances, yes. And those, yes. I was making the point that the highest the case can be put is that the facts are a classic example of where oppression and remedy will bite, and that liability on the facts is inevitable, as I've already explained, whether Section 280 is satisfied and the appropriateness of an order turns upon equitable considerations and the exercise of discretion. It's therefore not possible to define when a court may choose to grant relief by imposing a liability upon the directors. Put another way, the imposition by a court of a personal liability cannot properly be described as inevitable. However, there is in any event a difference between the situation where a remedy has been granted and the situation where it has not been granted. In the first, there's an existing liability. In the second, there is no liability, just the prospect of potential liability. My lords and my lady, then the final point, does the word liability include potential liability? And in that context, may I say something in relation to the dictionary definition at 1433? My lords, my lady, on careful analysis of the definition, the word potential is not being used in this definition to open up liability to every potential of liability. What the draftsman of the definition had in mind is explained by the example which is then given of the surety. It's to deal with that sort of situation where a surety is under a contractual obligation whilst the debt is guaranteed, the person whose debt is guaranteed is not itself under a liability. The surety is only under a liability in the sense that he is undertaken to be answerable if the debt becomes payable and is not paid. And it's only potential in that sense, and it's not a suggestion that one can give the word liability. You can say that it's equivalent to potential liability in circumstances. In our submission, the draftsman of the statute has carefully chosen the word liability. The distinction exists between that and references elsewhere in the statute to contingent liability. When the draftsman wanted to refer to contingent or potential or inchoate liability, they could have done so. In our submission, however, it all comes down to the fundamental point that a distinction is being drawn between liability existing in law on the one hand and relief which may or may not flow but depends upon the exercise of a discretion. In our submission, Section 272 is not drafted with that in mind, and I would suggest that around the world, company lawyers would be surprised if they were told that the word liability in this context includes the possibility of a discretionary remedy being exercised in one way rather than in a different way. Unless I can assist your lordships and your ladyship further, those are my submissions.
Well, thank you very much, Mr. Hofmeier. Well, this is an interesting problem that you've given us to consider. We're grateful to counsel on both sides for all their assistance. We'll now take time to consider what advice we shall humbly tender to Her Majesty.